our firm represents a lot of repeat DUI offenders. And the first question people ask, let's say it's their second offense, second allegation, they've been convicted 5 years ago. Well, what am I facing? Well, that's a very valid question, and it gets very serious. So first of all, I'd like to talk about what the Ministry of Transportation is going to do versus what the court's going to do, because there's two different schemes and you're facing penalties from both. So first of all, for a second-time offender, if you're charged by the police, they're going to tow your car. It's going to be kept in an impound for 7 days. These are before you're even found guilty. There's going to be a 90-day administrative license suspension. You're going to have a $550 fine, and there's mandatory alcohol reinstatement. That's even for a person who's potentially innocent. Once you're charged, you're facing those ministry requirements. That's a given. There's no way around that. Now, what's the court going to do if you plead guilty or are found guilty? So, valid question. First of all, you're facing a mandatory minimum 30 days in jail. So if the Crown relies on notice of the prior record, the Crown says, look, we're relying on that prior record, you're facing at least 30 days in jail, and it escalates up from there. I mean, that's the minimum. A lot of times you're going to be facing a more significant jail term if it's an aggravated situation, for example. You're going to lose your license from the court for a minimum of 2 years, but the ministry is going to take your license for 3 years. Those run at the same time. The court can take your license actually from 2 to 5 years if they want. Bear in mind the minimum's 2 years. So that's what you're facing in terms of jail time. And again, I see clients get longer jail time. But the important point to know is sometimes you can negotiate with the Crown not to rely on the prior record. So if you have a prior record within the last 5 years, the Crown has directives of Ontario. We have to rely on that. We have to treat it as a second. We have to at least ask for the mandatory minimum of 30 days, if not higher. What if it's beyond 5 years? Well, each Crown's office is different, but sometimes we can negotiate to avoid them relying on that and avoid the jail term. So there's some discretion there, but there's some Crown's offices that are pretty mean-spirited. They like to rely on records from 10 years or more ago again. But if you can point out an issue with the file, you may be able to avoid it, or you maybe even get the charge withdrawn if there's a major issue with the file. So beyond that, you're looking at what's called stream D ignition interlock, which means if a judge allows you to apply for interlock, and if the ministry approves you, so 9 months from the date you are sentenced, you could get an interlock device on your car and have it on for an additional 18 months instead of facing that 3-year license suspension automatic. So Stream D is a nice thing to get if you qualify. And of course, your insurance rates are going to skyrocket. So there's all sorts of criminal penalties. There's a separate scheme for the Ministry of Transportation. They get you, and the ministry gets you even if you're not, even if you're innocent. Bear in mind, you've lost that license right away for 90 days. What happens for a third time or even a fourth time offender? Well, they're really up against the wall because you've got the similar type roadside suspensions, 90 days, towing of the car, and your car's in an impound for, I believe, 30 days, actually, a little longer. What if you're now found guilty and you've got 2 priors, and those priors are within 5 years? Well, for sure, the Crown's going to seek at least the mandatory minimum of 120 days. I see some sentences up to 6 months on these cases because judges are taking it increasingly serious. You're also going to face a long driving prohibition from the court. The court might only take your license, though, for, say, 3 to 5 years or something like that. But I'll tell you, the ministry takes it for a lifetime. That's right. If you have, the ministry goes back 10 years on their charges. If you've got 2 charges in the last 10 years, you're facing a lifetime ban after your 3rd conviction. Now, that's reviewable after 10 years. They'll review it, and if you are rehabilitating yourself, you may get your license back after 10 years, after some time. Here's the catcher, though. If you get a 4th, another one, again, you're going to face a mandatory 120 days. I dare say it's going to be far longer than that. That's the minimum. The ministry is going to take your license for life. You'll never drive again. This is not reviewable, and the judge is going to treat you very harshly. So, very serious penalties. It does help to get a lawyer, hire a lawyer often. You can often avoid the Crown relying on priors, and if you don't and you're found guilty, well, you have to face the music. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.